it really gives us great pleasure to host this webinar by David Chambers and SCIA on arbitration with a specific focus on the role of Hong Kong court in terms of how it supports arbitration proceedings in Hong Kong. So as you would appreciate, arbitration has become an increasingly popular mechanism for resolving disputes, not just in Hong Kong, but also in other jurisdictions, including mainland China. And Hong Kong has always been a very popular seat of arbitration, and it is generally recognized as a leading international arbitration hub. So there are, in fact, a lot of things to talk about in the context of arbitration. But for today's focus, we would explore the dynamics between court proceedings and arbitration proceedings, and in particular, explore how the Hong Kong court tends to support arbitration proceedings in shaping Hong Kong as an international leading arbitration hub. So for Terri, although she's quite junior, she already has quite a bit of experience in advising and handling arbitrations. In terms of today's presentation, as Harold has mentioned, we will give our presentation in English, but towards the end, there will be a 30-minute summary, and we will give the summary in Mandarin so that we can have a bit of more relaxing and flexible chit-chat. And so as to not to make the presentation too boring, we'll try to split our airtime in alternative roles so that you can have a bit of a change. So while Terri will walk you through the arbitration agreement, which is a big topic for today, because it is the source of jurisdiction for arbitration proceedings on the tribunal. I will then talk about another big topic, which is enforcement of arbitration award in Hong Kong. And you will then have a more strong feeling as to how the Hong Kong court tends to support enforcement proceedings in giving effect to the arbitration award already obtained in Hong Kong. We'll also touch on the miscellaneous applications like stay of execution, as well as security for cause applications, as well as putting the company in liquidation as an alternative to pursuing arbitration proceedings. And then we will also explore a relatively new interim measure arrangement, which of course is proclaimed by mainland China in support of cross-border arbitrations for disputes between mainland China and Hong Kong. So without further ado, I'll pass it on to Terri to go through the arbitration agreement.
Sure. Oh, sure.
Take the screen. Yeah.
Is it share screen?
Yeah.
Share screen.
Share.
May. Thank you. Thank you, Connie, for that introduction. So we're going to start with the arbitration. So as Connie says, is the source of the jurisdiction. An arbitration agreement is defined under Section 19 of the Hong Kong Arbitration Ordinance, which adopts the UNCITRAL model law definition. It is an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. The arbitration agreement is usually incorporated in the contract that gives rise to the dispute. But even when there is no arbitration clause in that contract, the parties can subsequently mutually agree to do so and enter into an arbitration agreement as subsequently. And the protection is that it also has to be in writing. It is insufficient if the arbitration agreement is oral, but it can be recorded in writing after the effect. If the parties have an arbitration agreement, then with limited exceptions, they cannot go to court. Under the arbitration ordinance, under section 20, if one party tries to go to court, despite the dispute being governed by an arbitration agreement, the other party can apply to the court to stay the proceedings. This is similar to an exclusive jurisdiction clause, which the court will respect. So the procedures of going for stay of execution, it would usually be when the proceedings have commenced and before a defense is submitted. This is pretty important because if you submit a defense, you will be taken to have submitted to the jurisdiction of the Hong Kong court. At this stage, the defendant can then make an application by summons supported by an affidavit to the Hong Kong court for the stay of proceedings. In this case, Tommy CPC, the former Chief Justice, Jeffrey Ma, asked 4 questions in deciding whether to stay the proceedings in favor of arbitration. The first question is whether there is an arbitration agreement. Second, whether the arbitration agreement is null, void, inoperative, or incapable of being performed. Third, is there in reality a dispute or a difference between the parties? For this question, the old approach of the court was that it needed to be a genuine dispute and there had to be an arguable defense to the claim brought by the plaintiff. But now the court no longer reviews the merits. A dispute will exist unless there is a clear and unequivocal admission not only of liability, but also of quantum. So it will be quite hard to dispute the arbitration jurisdiction on this third question. And finally, whether the dispute or difference is within the ambit of the arbitration agreement that is made between the parties. So as can be seen, it's quite similar to an exclusive jurisdiction clause. So for the existence of the arbitration agreement, in this case, specific crowd engineering, Justice Burrell holds that to successfully get a stay, the party relying on the arbitration agreement only needs to demonstrate a prima facie case or a plainly arguable case that an arbitration agreement existed and bound the parties. So once a good prima facie case is shown, the court will refer the matter to the arbitrator, who gets to determine substantively whether there is an arbitration agreement or not. That arbitrator will have the benefit of oral testimony from witnesses from both sides and receiving evidence to demonstrate, to decide whether there was actually an arbitration agreement or not. So this is also called competence, which means that the tribunal itself has the jurisdiction to determine its own jurisdiction. So for example, in this case, the contract in question was a construction contract that was not signed. And because the arbitration agreement was in the construction contract, there was a dispute as to whether the arbitration agreement was valid or not. And in this case, even though the construction agreement was not signed, there was a prima facie case of a valid arbitration agreement because there was evidence that the parties acted in accordance with it. So they turned the matter to the arbitration tribunal, who would be able to decide that whether it had the jurisdiction or not. So in this case, the matter was stayed for arbitration. On the other side of the line, this case PCCW Limited, there was no prima facie case. So here there were 2 clauses in question. First, clause 4.3, which was specifically for billing disputes. you can choose to submit the difference to Hong Kong courts. And there's a second clause, clause 11.3, where that either party may require disputes arising hereunder to be settled by a binding arbitration. Here, the defendant had made the election to arbitrate by submitting the notice. But the question here was whether clause 11.3 also covered billing disputes. The dispute in question was a billing dispute. And the answer was no. The court held that the clause 4.3 was self-contained. It was a self-contained provision on how a dispute over billing would have to be determined. So it must fall outside clause 11.3. However, in this case, the Court of Appeal reaffirmed it was important for the court not to usurp the function of arbitrators. And unless the point was clear, the matter should be stayed for arbitration. And on these facts, the court held that this was a clear case, that the arbitration agreement did not cover billing disputes. So a stay was not granted. And turning to the question of whether the arbitration clause covers the scope of this dispute, the case that is most often cited is Fiona Trust. This is a House of Lords case from England that has been applied in Hong Kong. At paragraph 13, the English House of Lords indicated that there is a presumption that rational businessmen would want all their disputes to be resolved in one place and not have to go elsewhere. So as can be seen, the presumption lies heavily in favor of the arbitration agreement being wide enough to cover most disputes that come up. Another question to ask is on the jurisdiction of the arbitration. So for bills of exchange, which include checks, in this case of CA Pacific Forex, it was held that generally the arbitration agreement for the underlying contract, which has been subsequently paid for by the check, the arbitration agreement does not cover the check. There is a presumption against taking bills of exchange into arbitration, but this is not invariably the case. It is only rebutted if there is a plain manifestation in the arbitration clause that the arbitration clause would also cover bills of exchange. Second, there are unfair prejudice proceedings, which are proceedings that are disputes between shareholders. And normally the sought after relief is for one shareholder to be bought out by the other shareholder. The disputes are usually brought on the basis of shareholders' agreements or breaches of the Articles of Association or breaches of the general law and the general law governing companies. In this case, Fulham Football Club, the underlying rules, which were akin to the Articles of Association for that company, contained an arbitration clause. But the petitioner had brought court proceedings and argued that the subject matter could not be arbitratable because of the court's supervisory jurisdiction over companies. But the court did not accept this argument. The court held that this was an internal dispute and it could go into arbitration. So the petition was stayed. Similar to this are just and equitable winding up petitions, which are also proceedings where you rely on internal shareholder dispute grounds to seek to wind up the company. So the issue with this is that the relief of winding up a company has public effect and does not just bind the parties within the arbitration. But nevertheless, in this Hong Kong case, re Quicksilver Glorious Sun, the court held that the substance of the dispute between the parties, between the shareholders, was actually governed and covered by the arbitration agreement. And unlike insolvency, it wouldn't affect any other parties, such as creditors. It is essentially a private dispute for a solvent company. It concerns the interests of members. So the court held that it could stay the proceedings for arbitration. And if the tribunal decides that winding up is appropriate, the petition can then be dealt with by the court. Turning to winding up and bankruptcy in the insolvency context, this is a situation where the underlying debt for that petition is subject to an arbitration clause. The most famous case of Lasmos held that a court would generally exercise its discretion to stay the petition pending determination of an arbitration in respect of the debt, as long as 3 conditions were satisfied. First, that the respondent to the petition disputed the debt. Second, that the debt was governed by an arbitration clause. And third, that the respondent had actually already brought arbitration proceedings. This has given rise to controversy and has been argued before the Court of Appeal, but it has not yet been overruled. And at the moment, this still stands. There is a recent Court of Appeal case, Re Gai Kwok Hung Lam, which dealt with bankruptcy proceedings. This was not in the arbitration context. It was in the, there was an exclusive jurisdiction clause in favor of New York courts. And the Court of Appeal did not approve or overrule Lasmos, but it still upheld the effect of the exclusive jurisdiction clause to dismiss the bankruptcy petition on the basis that there was a dispute that should first be determined by the New York courts. And it is possible that those same reasoning could apply to arbitration clauses, which have all along been dealt with similarly to exclusive jurisdiction clauses. And Connie is going to talk about enforcement of arbitration awards.
Thank you very much, Terry. So just now, Terry has discussed how the Hong Kong court, in the face of having an arbitration agreement, would tend to support arbitration proceedings by staying the court proceedings wrongfully commenced by a party who is subject to an existing arbitration agreement, or that the arbitration tribunal should have jurisdiction over that particular dispute. So now that was at the start of an arbitration proceedings or before the start of arbitration proceedings. But what if after the conclusion of arbitration proceedings, you have an award? Of course, where the losing party actually complies with the award voluntarily, then all things are good. You have no issue with that. But what if the losing party refuses to comply with the arbitration award? Then what can the winning party do? So in this case, the winning party would have to enforce the arbitration award. What do we mean by, when we say enforcement, what do we mean by enforcement? Enforcement in this particular context is to turn the arbitration award into a court judgment so that you can enforce it as a judgment in a particular jurisdiction. So this actually reinforces the benefits of having an arbitration clause and to resolve dispute by way of an arbitration is that you can have a multi-jurisdiction enforcement in the sense that you have one award, you go through the arbitration or the trial once, and then after you have the award, you can simply carry the award and enforce it in whichever jurisdiction that you want. And presumably, you would enforce it in more than one jurisdiction if the losing party have assets in more than one jurisdiction. So in this particular context, both Hong Kong and mainland China are parties to the New York Convention. And in Hong Kong, where one wants to enforce an arbitration award before the court, Hong Kong court, there are three particular sections which are quite important in arbitration ordinance. Section 84 generally talks about how to enforce or the power for a Hong Kong court to recognize and to enforce an arbitration award. It is by way of a summary procedure, which we will then go through in slightly more details. Section 87 then specifically deals with enforcement of New York Convention award. And for Section 92, it specifically deals with enforcement of PRC or mainland award. What it does is really to bring in line the two particular types of awards and make it consistent. So in the eyes of Hong Kong court, whether you have a New York Convention award or whether you have a PRC or mainland award, which is produced by tribunals in the mainland, you can the winning party can enforce it before the Hong Kong court in precisely the same way. One of the ways is to enforce it by way of Section 84, which is a summary procedure. Alternatively, Terry will walk you through in slightly more details. You can sue on the award by way of a common law action and to enforce it. But that is a less popular choice to do so because as I go through in slightly more details later, you will see that the summary procedure is a very convenient and quick procedure, which again demonstrate how the Hong Kong court support arbitration proceedings is by way of a very quick enforcement procedure. So this is the body of Section 92, but I don't think I need to read out the section, but all that it means is that subsection 1A, you can sue on the award by an action in Hong Kong. So in other words, you can commence a court proceedings and to go through the motion and to sue on the award. But this is not always a recommended choice to do so because you have to start all over again and for the Hong Kong court to try the merits. Alternatively, which is the more popular procedures, and we see it day in, day out in Hong Kong court for enforcement of arbitration award by way of a summary procedure. That is subsection 1B. It's in the way in which Section 84 applies, that is summary procedures, which gives effect to applying the summary procedures for a mainland award. So basically, what is a summary procedure in enforcing an arbitration award? So in short, you can see that Section 84 is the governing section, which basically applies to awards both made in or outside Hong Kong. And if we look at Section 92, it also applies to mainland award. It will basically tell you that any award both in or outside Hong Kong is enforceable in the same manner as a judgment of a Hong Kong court, as long as the Hong Kong court gives you leave to enforce it. Now, how do we have leave to enforce that? Where, again, we can see that why we can say Hong Kong court is strongly in support of arbitration proceeding. You will see that once leave is granted to enforce the award as if it is a Hong Kong court judgment, it will be very difficult to appeal that decision. By appealing that decision, it means that the Court of Appeal would overturn that decision and to take away the leave and to set aside the enforcement proceedings. You will first need to have a leave to appeal. So you need to have permission to even begin to appeal against the fact that this lower court has given leave to enforce the award. So we can see that it's very difficult. Now, if we look at what do you mean by summary procedures, what is necessary to apply for leave to enforce the proceedings? If we look at an example under Section 94, which deals with the mainland award, but it's the same for any award, New York Convention award or any other award, both in and outside Hong Kong. First, you need to have a duly authenticated original award or at least a certified copy of it. So you need to first produce the award for the Hong Kong court to see you already have an award in your favor. Now you also need the original arbitration agreement or at least the certified copy of it. When we say arbitration agreement, it's usually within the same underlying contract that gives rise to a dispute for arbitration to resolve that dispute. So you need to produce that contract. If the award is not in Chinese nor English, then you need to translate that into the official language. Of course, in Hong Kong, the official language is English and Chinese. So you have to certify that to be in another, if it's in another language, say other civil law jurisdictions, European jurisdictions, then you need to have a translation into English or Chinese. This is the past version, which have restrictions on enforcement of mainland award, but I don't think we need to deal with it because we only need to remember that as from the 19th of May 2021, this is already a repeat. So in short, the only restrictions on enforcement of mainland award has been taken away. So in other words, this again reinforces how Hong Kong and the Hong Kong court would tend to give effect to enforcement of mainland awards and to bring it in line with other convention awards to give it support to arbitration proceedings. Now we see that when we apply for leave to enforce the award, we need to have the award, we need to have the arbitration agreement. But how then do we make the application? The application is governed by Order 73 rules of the High Court. It talks about requirements that you need to do and the steps you need to take with. So in short, it is an ex parte application. What do you mean by ex parte application? So ex parte application means that the winning party will go alone before the court without notifying the losing party. So it's a ex parte application without participation of the other party. So we only have one, it's a one-sided application. There's no right to respond in that particular state, at that particular stage. So you need to have an originating summons, and then you have a supporting affirmation to set out the fact that you have an arbitration agreement and to produce the arbitration agreement and that you have an award in your favor and to produce that award and to tell the court that which part of the award or has not been complied with. Of course, if the award has already been complied with, then obviously you don't need to enforce the award. So common sense dictates that when you need to go to the court to enforce the award, it means that the award remains outstanding and you need to tell the court that the award remains outstanding. So you need to turn it into a court judgment to compel the debtor or the losing party to comply with the award. At that stage, where it is still an ex parte application, the court will grant an order to enforce the award, but it does not take effect immediately. You have 14 days to serve that order on the losing party. And within that 14 days, you cannot enforce or you cannot start to enforce the order or the award because you have to give the other side. Remember when I say at that stage it's an ex parte application, but now this is the second stage. You have 14 days for the respondent to take out an application to set aside the enforcement. So in other words, if a losing party wishes to dispute or to resist enforcement of the award, they have to make an application within that 14 days. So thereafter, it will become a two-party proceedings application. So the respondent can take part at the later stage after leave has already been given. If the respondent does not take out any resisting application within that 14 days, then the applicant can enforce the award. But if he takes out an application to resist enforcement, then the court will have to deal with the setting aside application. Now, when we talk about ex parte application, there is a very prominent feature of an ex parte application, because only at the first stage when you apply for leave, only one party is before the court. The other side cannot make any submissions or response to resist the application until 14 days later. There is a positive duty on the part of the winning party to seeking to enforce the judgment to comply with all normal ex parte applications before the Hong Kong Court. There is a duty of full and frank disclosure made to the court. In other words, you have to make full and frank disclosure of things, including things which are beneficial to the debtor or the losing party, or which points to weakness of your case in enforcement. You have to tell the court. That is to make sure that the proceedings are fair, because the other side cannot at that stage address the court and to make response. And that's a very important consequence of not complying with that full and frank disclosure, is that if at the end of the day, the court realizes that you have not complied with a full and frank disclosure, or there is a material non-disclosure, the court can set aside the leave for enforcement. I have tried once, and there's a case which I've handled. It's called 1955 Capital Fund versus Global Industrial Investment Limited. The citation of this case is 2020 HKCFI 956. There's a US award creditor who has an US award in their favor, but the other side has taken a challenge proceedings to set aside the award in the US, but the US creditor come to Hong Kong trying to enforce the judgment, enforce the award in the form of a judgment. Leave was granted at the ex parte stage for the US creditor to enforce the award. But one of the resistance or the response at the second stage, where the respondent come out, the losing party, then say, oh, you have actually failed to comply with a full and frank disclosure, because the award creditor failed to draw to the court's attention that pursuant to the operative part of the award actually says that the debtor duty to perform the award was conditional upon no filing of an application to set aside the award in the seat of arbitration. So in other words, the award can only take effect if there's no application or after the expiration for the term to set aside the award in the seat of an arbitration. And in that case, the seat of an arbitration is in Delaware, in the US. Because the US creditor did not draw to the court's attention, because remember I mentioned that the respondents actually take out challenge proceedings to set aside the award in the US. So the court in Hong Kong then held the creditor had failed to comply with a duty of full and frank disclosure and set aside leave for enforcement. So that is something that we need to bear in mind, that although the Hong Kong court is generally very supportive of enforcement of arbitration award, there is to a certain extent some duties that the award creditor must comply and to take steps to comply before the court will give effect to the award. That is to make sure that there's integrity of proceedings and there's fairness in the proceedings. So coming back to having complied with that duties, what then the court would look at in the face of an enforcement application to recognize and to enforce the arbitration proceedings. There are 10 basic principles which is set out by KBNS by Ms. Madam Justice Mi Chan, who is mainly responsible for this sort of enforcement or arbitration, who is the judge sitting in the arbitration list. So you see why we say the Hong Kong court is very supportive of arbitration proceedings. The primary aim of the court is to facilitate the arbitration process and to assist with enforcement of what. So that's one of the cardinal principles, because give effect to parties' agreement and parties' autonomy. The parties chose to resolve the dispute by way of arbitration proceedings. The court has to respect that, and therefore the court role is to facilitate the arbitration process and to assist with enforcement of the award. So in other words, the court will only interfere the arbitration of the dispute where it is expressly provided under the ordinance that the court can interfere. So that is why we say Hong Kong court in many of these judgments have repeatedly emphasized the court adopts a pro-arbitration stance. And therefore, the enforcement of arbitration award, as we can see in Principle 4, should be almost a matter of administrative procedure, and the court should be as mechanistic as possible. So it's a very quick and mechanistic procedure. Once the creditor comply with full and frank disclosure, the court is always prepared to enforce the award, subject to the very limited grounds that the court will not recognize. And Terry will cover that in details. But in short, the court will not go behind the award. In other words, even if the award is not reasonable or make some error of facts or make some error of law, it is not an appeal procedure. The court will not question those mistakes or go behind the award and say, oh, I think the tribunal is wrong. The tribunal ought not to rule this and that. The court will not do this. It is not an appeal procedure. The court will only look at the face of the award. There's a valid award on the face of it. The creditor had complied with full and frank disclosure, and they will take the box under the ordinance whether there's very limited grounds not to recognize the award. If there's no such grounds exist, then the court will give leave to enforce the award. So this again reinforces that it is very difficult for the court not to enforce the award, or for the debtor, the losing party, to set aside the award. Principle 7 is what I just discussed. It does not look into the merits of the underlying transactions or the award. It does not question the approach adopted by the tribunal in ruling a particular dispute. And that Principle 9 is also very important. Even if the sufficient grounds are made out to refuse enforcement, the court retains a residual discretion to nevertheless enforce the award, despite there's an existing valid ground. And the grounds actually are very, very narrowly construed. Again, this reinforces the court is very reluctant to set aside a particular award unless those grounds really can be made out. And Terry will go into those details, but very briefly, those grounds are usually against public policy. The tribunal did not have jurisdiction to deal with the dispute, or that it did not give the party sufficient opportunity to present their case, etc., etc. So for that, I'll pass it to Terry to discuss those very narrow grounds.
Yes, thank you, Connie. So as Connie said, it's really just very narrow grounds. The court, Hong Kong courts are very supportive of arbitration, and they will, their role is essentially just that of an overseer to ensure that the arbitration has been conducted fairly, and lending the court's support in enforcing that and making that award effective. So the narrow grounds on which the award can be refused enforcement, the first is incapacity. So it means any legal incapacity imposed by the law, such as the incapacity to enter into a contract. Second, that the arbitration agreement was not valid. And that third, that they have not given proper notice, they haven't had proper notice of the arbitration or hasn't been able to present their case. So these are seen as just violations of the minimum requirements of due process. So examples of this can include if the other party has not even had notice that the matter is going into arbitration, denial of a party to attend the hearing, to present argument and evidence, or the right to be present at the hearing. If the award exceeds the scope of the submission to arbitration, if the arbitral authority is not as agreed by the parties. So this also emphasizes that the arbitration agreement really is based on the parties' agreement and their autonomy to submit to the jurisdiction of the arbitration. If it has not actually been binding, so again, this is to do with the award itself. And if it's contrary to public policy. So really, this is the only factual ground that the court might look into. But this really is very narrow as well. The court has held that it must violate Hong Kong's most basic notions of morality and justice, such as the rules of natural justice. So or if the award was procured by fraud. So again, this is a very high burden to establish. So this is an example of a case where the respondent has successfully, it's an example of where the court, the applicant seeking to set aside the award tried to argue that the arbitration institution was not the one that was agreed by the parties. And it also goes to show how actually the courts are reluctant to set aside awards on technical grounds. So the arbitration institution, as agreed in the arbitration clause, was the China International Economic and Trade Promotion Arbitration Commission, but the actual arbitration commission was the CIETAC. So the court disagreed and said that even though the names are very similar, this did not fall within section 95(2)(e), because at the time of the agreement, the CIETAC was actually the only mainland arbitration institution that could deal with foreign-related economic disputes. So this was just considered a clerical error, and the true meaning of the parties was the CIETAC. So the award could be enforced. And this case, a recent case, is one of the few examples where it has actually been set aside. So the award was not enforced. But the facts were quite, the high threshold was really met in this case. So here, the respondent company was incorporated in Hong Kong and carried on a timber retail business. There were 2 directors, and one of them entered into a contract to sell marble to the applicant. And the contract itself was of a very, very large sum, which was many times larger than the company's entire sales revenue. And the contract says that the company would be liable for 2.2 million yuan for each day of delay in delivery. So it really was quite a serious contract that was not very favorable to the company. So the applicant commenced arbitration on this contract, and that director who entered into the contract dealt with the arbitration on behalf of the company. An award was issued, which awarded the award was against the company, and the company sought to set aside this order enforcing the award on the grounds that first, the director was not authorized to enter into the contract, which contained that arbitration clause. Second, that the company was actually not given notice of the arbitration proceedings. Third, that the enforcement of the award was contrary to public policy. And fourth, that there, on a ground of material non-disclosure, one of the grounds that Connie has talked about. And ultimately, the court did set aside the enforcement of the award. And the reasons were as follows. First, that the director actually did not have the authority to enter into the contract that did contain the arbitration clause. So this is to do with company law principles and how internally the company, who has authority to act on behalf of the company. Because in this case, there were two directors, and it was held that that director did not have the authority to enter into that contract. Since the arbitration agreement was in that contract, the arbitration agreement was also impeached. Second, the court also considered from the evidence that that director was actually involved in a scheme with the applicant to orchestrate the award in order to wind up the company. So this was not in good faith. And this was also used as a ground of that it would be contrary to public policy to enforce the award. And third, on a related note, that the company had actually not been given proper notice at how the director who conducted the arbitration on behalf of the company didn't have the authority to do so. So, as mentioned, the balance really is to be drawn between the need for finality in the arbitral award and to enforce it, and the need to protect the other party against the unfair conduct of the arbitration. In N and C, it was tried, the parties seek to set aside the award, tried to argue that the tribunal failed to, was unable to present its case, whether it exceeded its powers, failed to, failed to comply with due process and fair procedures. But here the court held that as long as the parties had a reasonable opportunity to present its case, then the award cannot be set aside. Importantly, the court also said that whether he has given sufficient reasonings of his findings and the quality of the arbitrator's reasonings, these are not matters of consideration in an application to set aside for serious irregularity. The issue is not whether the arbitrator came to the right conclusion. The sole issue is whether he has committed a serious irregularity in coming to the conclusion that he did. So it's come to a situation where it's possible to set aside an award by reason of procedural irregularity, but not of substantive irregularity. So for example, where the tribunal has made a wrong factual error or applied the wrong legal principles, this would not be a ground to set aside the award. Further, when there is an application to set aside an arbitration awards enforcement, the Hong Kong court can order that party to provide security for costs. And this was seen in the case of X and Jenny Chen, where again, it was Madam Justice Mimi Chan who granted security for costs. Security for costs are essentially where the party, so usually under Hong Kong court proceedings, the losing party would have to pay the other side's legal costs. And security for costs is to give protection to a defendant that his legal fees will be paid for at the end of the action if the defendant wins. So in this case, Madam Justice Mimi Chan did grant security for costs. Relevant to that discretion to grant security for costs is the strength of the party's case. And here the court did consider the merits of the plaintiff's arguments on whether there are sufficient grounds to set aside the arbitration award. And here the plaintiff did not have assets in Hong Kong, but only in Singapore and Malaysia. So the balance of justice was in favor of granting security for costs. So this really is an example where if you seek to set aside an arbitration award, you could have security for costs against you. Okay, and I'll hand over to Connie to talk about stay of execution.
So I think well, Terri has just given us a very comprehensive background as to the very narrow grounds that a losing party can try to set aside the award or try to resist the enforcement. Of course, we've seen a very rare example of setting aside in the Guangdong timber case, but that was very unique circumstances where there was actually fraud involved. So that's a very rare example of a successful setting aside application. But as Terri has mentioned, in Hong Kong, the losing party will usually have to pay the cost of the winning party. So even in these sort of enforcement proceedings, if the losing party fail to set aside the award or fail to resist the enforcement of the award, then normally they will be ordered to pay costs. And they would be ordered to pay indemnity costs. What I mean by indemnity costs is to pay costs on a higher scale. So that again reinforced the Hong Kong court's pro-arbitration stance. It's really by ordering a cost on a higher scale to discourage pointless or unmeritorious application to resist the enforcement of the award or to pursue a pointless or unmeritorious setting aside application. So again, we can see that in many aspects, the court really adopts a pro-arbitration stance. Now, in a very narrow topic, stay of execution, I think I can be fairly quick because what it talks about is that where there is already an arbitration award, whether one can apply to the court to stop the execution of that award based on the fact that they have a cross-claim. It's very difficult. And again, S&G is the case. I don't need to go into the details of this case. It really talks about that. The court again recognizes the fruit of an award or the successful party should not be deprived. So it would be very difficult for a stay of execution to be granted. And I personally have not seen a successful case of that because even if there's a cross-claim, of course, you can still pursue a cross-claim. It doesn't mean that the court would stop the enforcement of the award of the winning party. The losing party can still pursue their cross-claim against the winning party in another forum or in another jurisdiction. It does not mean that the court will not give effect to the award already given in favor of the winning party. So that is, I think it's the only point that we need to take home. We don't need to deal with the facts of that case.
Okay, and so Connie has told us about the summary procedure to enforce the award, but there is also another way to do this, which is an action in common law on the award. So the basis of this jurisdiction is that with every award, there is an implied promise, which is a contractual obligation in every arbitration agreement that the parties will perform the award. But compared to the summary procedure, this will take a much longer time. It's really just the same as any Hong Kong civil action and the steps to start a Hong Kong civil action, which is a much longer process. As can be seen, there are quite a few stages. You will need to start the action by writ of summons. It will go into pleadings, discovery, where you exchange evidence, and then there will also be a trial. But even in using the action on an award, the court is only concerned with the jurisdiction of the tribunal. So it is no defense, for example, to say that there was an error of fact or law, or there's been misconduct of the arbitration. So the plaintiff will have to prove that there was the contract, the arbitration agreement, the dispute was within the terms of the submission, the tribunal was duly appointed, the award was made, and that the award has not been performed. And in breach, and if it's shown that there is a breach of this implied promise, then there can be the remedy of damages on this for failing to honor the award. So this is where it contrasts with the summary procedure. The action on the award is much more flexible because for the summary procedure, you are limited by section 84 of the subsection 2 of the arbitration ordinance that the court may only enter judgment in terms of the award. But for action on the award, the remedies may include the recovery of damages for the breach of that implied promise, which can go beyond just the terms of the award. So really in practice, there are these examples where flexibility may actually be better and the action on the award may be more appropriate. In the case of Xiamen, the contract in question was to transfer shareholdings to develop land, and the award was granted for specific performance to transfer that shareholding. But in the meantime, the defendant had already disposed of his shareholding, so it was no longer possible to perform the award. So the Hong Kong Court of Final Appeal actually granted damages on the award. This could not have been achieved by the summary process, which is just enforcing the terms of the award, which is just specific performance. Second, this is the case of Dalmia Cement. This was an English case where the award itself said the defendant had to pay money in India, but the plaintiff wanted it to be paid in London. So by bringing the action on the award, and because the remedy was for damages, this could take place in London. And the third circumstance is where the award itself is not clear to the manner of performance. So that the court has more flexibility to make orders to resolve this.
Okay, I think I'll be fairly quick to cover topic 8 and 9 in terms of how liquidation as an alternative procedures. So when we have an award, apart from applying for enforcement, we can also choose to present a winding petition or a bankruptcy petition to put the losing party into liquidation. And in this case, Lucky Resources, it's very clear. It says that this is not enforcement, so you don't need to apply for leave. You can simply present the petition based on the award, which says that you are the winning party and they've not complied. But what about before starting the arbitration proceedings? You don't want to go through arbitration. Can we simply present the petition and try to wind up the company or to put the person in bankruptcy by saying that they have no dispute to, or they have no case, no defense, no dispute, etc. Can we directly put those companies and individuals into bankruptcy or insolvencies. Just now, Terry has already provided the answer, actually. In the Lamor's case, the court, again, has adopted a very poor arbitration stance. Even if the court thinks you have no dispute or no defense to the claim, because the parties have opted to resolve their dispute by way of arbitration, the court must respect that party's wish and give effect to the arbitration agreement. It will dismiss the petition or state the petition, provided that the three conditions that Terry has mentioned are satisfied. And that, of course, include the dispute is covered by the arbitration agreement. The arbitration agreement is operative and valid, and that the parties have already taken some steps to commence arbitration or to commence the arbitration and to produce evidence to that effect. There is another approach by another judge, which basically says that no, we'll use the old way to deal with it because winding proceedings are a collective proceedings. There are other creditors' rights being involved. So where the court is not satisfied, there is a dispute to the debt. Where the court is satisfied that there is some dispute to the debt, there's no dispute to that, then the court will nevertheless proceed to wind up the company or to put the individual into bankruptcy, even though there is an arbitration clause which governs the underlying transactions. That case is called We Hong Kong Baiyuan International Business Company. It's a 2022 case. But it seems that the Court of Appeal case in Gai Kwok Hong Lam, which Terry has talked about, basically seems to suggest that it will adopt the Lamor's approach, the poor arbitration stance. Of course, it's not a case directly on point because it deals with exclusive jurisdiction clause, not an arbitration clause. But the rationale we can see is similar. Really, the court should respect the parties' autonomy and the parties' agreement. If they have chosen to deal with their dispute in another forum, say, for example, by way of an exclusive jurisdiction clause, or by way of arbitration, by way of an arbitration clause, the court should respect that and let the dispute be resolved in those particular forums, instead of trying to wind up the company or to put the individual into bankruptcy. So that, again, we see the interface between the court and how it is trying to basically progress with the arbitration stance in every other aspect, not just in the enforcement aspect, but to basically cover the loopholes where one tries to avoid the enforcement or one tries to avoid the arbitration and proceed to liquidation directly. We can see that the court in that particular front is very minded to adopt a pro-arbitration stance. Now I come to the final topic about how the court can support arbitration proceedings, and of course with the support of the PRC government and the PRC court. It's the latest arrangement on interim measures on cross-border arbitration that was signed in 2019 and commenced in 2019, the 1st of October. So in short, before this mutual assistance arrangement, in Hong Kong, there's a section 45 of arbitration ordinance, which can provide jurisdiction for the Hong Kong court to order any interim measures, including waiver injunctions, freezing injunctions, in aid of arbitration proceedings, both in or outside Hong Kong. I have personally experience dealing with section 45, but in short, previous to this arrangement, there's no equivalent procedure in mainland China which gives effect which can actually order interim measures in aid of arbitrations outside mainland China. But this is the first arrangement which gives effect to it. I don't think we need to go into details of the actual articles, but in short, it's really to recognize that where there are parties to arbitration proceedings in Hong Kong, they can apply to the relevant mainland court for interim measures. Well, why do we need interim measures? For example, where one of the parties actually have assets in mainland China, and you can see that they're trying to abscond or trying to dissipate assets. Before the start of the arbitration, you have to take steps to make sure that you can apply to freeze those assets such that they can't abscond or dissipate the assets, because otherwise, you let them dissipate the assets and then you go through the arbitration proceedings, come back and find out, oh, the assets are already gone. You can't enforce the award. Even if you have leave from the mainland court or you have leave with the Hong Kong court, you can't enforce because the assets are no longer there. So this arrangement is very important to give full effect to protect the integrity and the effectiveness of an arbitration procedures. Now, of course, whether the decision of the mainland court should grant interim measures or not, it would have to be dealt with in accordance with the relevant mainland law. But the feature is that because in mainland, they do not recognize ad hoc arbitrations. So it must be an administered arbitration in Hong Kong, say, for example, administered by the Hong Kong IAC, HAIAC. So in short, in September 2019, that has already set up the list where the mainland court will recognize the administered arbitrations in Hong Kong, which, of course, as I've mentioned, include the HKIAC, HKMAG, and it does not cover the ad hoc arbitration. So these, again, deals with the procedures as to how one should apply to the mainland court. So far, there are already more than 20 cases made to the mainland courts, which has been successful in granting interim measures. And we usually need to take some steps to apply to the Hong Kong court, and usually one would actually make an application through the HKIAC. And then the HKIAC will be responsible for issuing the letter to certify that the case has already been accepted by the HKIAC and forward to the relevant mainland people courts. And then the application will be dealt with by the mainland court. Now, of course, when we make an application to HKIAC, you will need to of course, provide evidence. Say, for example, the arbitration agreement, and the arbitration proceedings will be started, and you discuss the background of the case and why you need to make this interim application. For example, you can see that the assets, say, for example, in Shanghai, in the examples that we've looked at, and you can see that the party is trying to dissipate the assets. We need the protection of the mainland court to step in to preserve those assets, to facilitate the arbitration proceedings which will be commenced. And then, of course, the HRIC may need to have some other documents. But in making the application to HRIC, you will need to translate the documents if they're not in Chinese into Chinese. And the HRIC is, again, very supportive of this, and in that it will not charge any extra costs. So I've included, for the sake of completeness, Section 45 of the Arbitration Ordinance, which has always been in Hong Kong, that the Hong Kong court would have jurisdiction to give and grant interim measures, including freezing injunctions, or to preserve evidence in aid of arbitration proceedings, both inside or outside Hong Kong. So again, this reinforces that the Hong Kong court is very supportive of arbitration proceedings. I have included two case studies, which is two cases that I have handled myself. I don't think that we need to go into that in very much details because of the time, but in short, there was a very popular singing contest program in mainland China, which perhaps you'll be able to guess which singing contest program was that. There's an IP and contractual dispute where the licensing agreement has been terminated by the production company, but the but the TV production companies was in the progress of producing the 5th series in breach of the licensing agreement and breach of some IP rights. So my clients were about to commence arbitration proceedings in Hong Kong because there was an arbitration agreement in the licensing agreement, which provides that the dispute would have to be resolved by way of arbitration in Hong Kong. But because they were already in the progress of advertising, preparing the 5th series, so we had to rush to court and apply for an interim injunction to restrain them from continuing with the production and the promotion, and that was actually granted. And at the end of the day, we were also successful in arbitration proceedings in Hong Kong, and we've represented the clients to enforce the proceedings, to enforce the award, and which was granted in Hong Kong. So the other case is again deals with a cross-border dispute between the mainland property investment group and the US fund investor. Again, we also had to apply for interim measures, and Hong Kong granted the interim measures. So thank you very much. That actually wraps up our presentation today. I'll use Mandarin to briefly summarize. 可能我可以简单的总结一下，就是我们可以看到这个跨境仲裁还有国际仲裁在香港来说是一个非常常用的争议解决的方法。有两个长处，就是第一是很快。因为如果你们知道的话，相对来说，就是在香港的法院去提出一个诉讼是比较慢一点。还有就是另外一个好处，就是一个保密的好处。其实一直下来，就是香港都是一个很受欢迎的仲裁地。也有一个很成熟的仲裁机构，就是 HIAC 香港国际仲裁中心。香港国际仲裁中心也是非常的支持一些非机构的这 ad hoc arbitration 非机构仲裁，也有自己一套的仲裁规则，就是2018年最新的rules of Hong Kong HIAC rules 就是自己的仲裁规则，也是跟其他国际仲裁机构的规则是接轨的。香港也是就是纽约公约的其中一员，就是我们可以从很多方面看到，就是香港政府在中央政府支持下很努力的打造，还有就是确定香港是一个很好的仲裁地。所以就是当然在政府我们在努力的打造上，也需要香港法院的支持。那我们刚才的 presentation 你们可以看见，就是香港法院在很多方面都是非常支持这个仲裁的。第一，就是在你如果有一个争议，是有一个仲裁的协议，那你违反了仲裁协议，在香港法院提出诉讼，你可以看到香港法院是很容易去搁置，就是 stay of court proceedings in favor arbitration， 就是要你们尊重双方的一个仲裁的意愿，就是你要去仲裁，你不要来法院。我们也可以看到，就是在这个执行的程序，香港法院就是会有一个机械式的程序，就是 mechanistic procedure。你可以看到，就是非常容易就可以执行一个仲裁裁决，还有就是非常困难去撤销一个已经有的仲裁裁决。所以你也有看到，就是从另外一个方法，就是你想逃避去执行这个仲裁，就是你可以我可以用轻判的方法去解决这个争议嘛。你也看到现在从2022年开始，就是法院也把这个门给关上了，就是也是很困难的，要用这个轻判的方法。如果法院看到你的争议是有一个仲裁协议，他 不会很容易的给你去用一个轻盘的方法，它一定要你尊重相关的意愿去仲裁。所以最后我们也看到，就是自从在2019年后，中央就是非常支持香港打造这个仲裁第一的一个措施，就是有这个法田仲裁保全协议，就是我们刚才说过，到现在已经差不多3年。3年以来，我们可以看到这个程序是常常会被用到，也是很有用的，是非常可以显示这个中央政府还有香港政府是非常支持香港成为一个国际仲裁中心。所以我希望我们今天的总结是对你们来说是可以看到就是法院在仲裁里面的一个角色是怎样去支持这个仲裁。那如果你们有什么问题的话，也可以问我们，可以大家都研究一下了。谢谢。